So the first article of the Constitution, as you all know, says that all legislative power is vested in the Congress. The second article vests executive power in the President. And the third article places the judicial power of the United States in the Supreme Court and any inferior courts that the Supreme Court may deem to be necessary as established by Congress. So our U.S. Constitution and 40 constitutions of states, 40 different states, specify that the government must be divided into 3 branches. So persons charged, as I said earlier, with exercising power in one of those can't exercise the power in another. And further, many of our constitutions, like the U.S. Constitution, actually has term limits. They don't want somebody to stay in power too long. Again, the thought was that that creates a tyrant, if there's unfettered power and unfettered ability to stay in. I found a quote from a lawyer down in Florida, the Florida Bar Association. And he said that the framers of the Constitution understood the requirement for separation of powers among the branches of the federal government was essential to the operation of the rule of law. This is Gregory Redmond. The Constitution deliberately provides each branch with authority to have a say-so about the other branches of government. The American rule of law is not a flawless one. It is a legal system operated by flawed people who are imperfect with their information and how they carry out their responsibilities. The American rule of law has no superiors, though, among its counterparts when we look at our judicial system, our executive and legislative, because the guiding light for all of us is the rights of the individual to life, liberty, and the pursuit of happiness. Now, I know we live in challenging times, and I know sometimes we think it just could not get any worse, that this is really a bad situation. But what's interesting is that the people of our country and our community have a deep respect for the separation of powers. The nation subscribes to the original premise of the framers of the Constitution that the way to safeguard against tyranny is to have this separate power of government among the 3 branches, so we have this checks and balances. And even when the system doesn't always work right, and sometimes we think we're paralyzed. You know, I heard a lady the other day, the comedian at the Correspondence said, you know, I'm here, I have no agenda, I don't plan to do anything, so anybody from Congress are to feel comfortable. You know, sometimes we have that feeling, but the reality is it's been bad in the past. And I'll give you a good example. I want you to think back, and I don't see anybody in the crowd who can remember this personally, but think back in 1935 when our country was in great turmoil with war was getting ready to break out into Europe. We had the Great Depression over here. And Franklin Roosevelt had proposed a number of pieces of legislation to try to get the country back to work. And the U.S. Supreme Court, which was very conservative from the time of the Civil War forward, they had been very conservative. They actually struck down 8 of Franklin Roosevelt's New Deal programs, including the National Recovery Act and the Agricultural Adjustment Act. And there was a lot of public sentiment against the Supreme Court. A lot of people were very angry, and they were beginning to question the constitutionality of judicial review. So they were mad at the Supreme Court. And as a result of this, there were all sorts of constitutional amendments being proposed at that time, some of which would require at least 2/3 of the Supreme Court to vote if they wanted to overturn any act of Congress. Another would allow the Congress to revalidate federal laws previously declared unconstitutional by repassing them with a 2/3 vote of both the House and the Senate. And some of them wanted to abolish the court's power to declare federal laws unconstitutional. Now, FDR was a smart guy. He was a great executive. He actually had experience working with the legislature, and so his hope was that all the anti-judicial public sentiment would grow and that there would be pressure against the Supreme Court. He avoided any direct references to the court when he ran in 1936. And after he won, though, he submitted to the Congress a plan for judicial reform. And I'm sure many of you have read about this, and it became known as his attempt to pack the Supreme Court. And given his success in the legislature and getting all these bills passed that the Supreme Court didn't like, everybody thought, well, he's got a pretty good chance of getting the legislature to go along. And in fact, just the opposite happened. Members of the legislature, including his own party, recognized what he was trying to do. And they became upset about it. And then the Supreme Court seemed to kind of catch on what was happening, and so they actually started finding constitutional or finding valid different legislation that had been passed. But Roosevelt decided to keep pushing forward against the advice, and so his idea was that he would change the number of justices on the Supreme Court. You know, if you can't win with the team you got, you just put some more team members on. So his proposal was that everybody that was over 70 got replaced with an additional justice, up to 15. So we would have a Supreme Court with at least 15 persons on, and he thought he'd have enough to get more than he could outvote all of them that were remaining. So once they turned 70, if they didn't want to retire, they put somebody on. Well, that was a big blunder. The legislature didn't go along with it. This party split. They had all sorts of problems in the Democratic Party. And FDR lost that particular, lost the momentum on that issue. And in fact, eventually it alienated a lot of the conservative Democrats.